Can a criminal court judge conduct a Sandoval application conference in chambers without the defendant being present? To find out, you have to read People versus Sharp, but it's 8 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Sharp. This is published by the New York Court of Appeals on October 17th of 2024. The issue in this case is whether the court, in a criminal case, can hold an in-chambers, off-the-record Sandoval conference to talk about what kinds of materials to allow to be used by the prosecutor to impeach the defendant's credibility outside of the presence of the defendant. Can an in-chambers conference take place, or does that violate the defendant's rights? To understand and appreciate the context of this case, the helpful background to know is that under Criminal Procedure Law 240.43, that statute requires the prosecutor, to let the defendant know in advance before trial what, if any, prior bad acts or prior convictions the prosecution seeks to use to impeach the defendant's credibility at trial. So the prosecution has to let the defendant know what list of things they want to use to impeach the defendant if the defendant chooses to testify. And the defendant has a right under the case of People versus Sandoval, the defendant has a right to have an advance ruling before trial about what materials will be allowed to be used against him or not to impeach him. And that allows the defendant to make a knowing and voluntary decision about whether to testify or not. The defendant knows he's going to be cross-examined about 100 different things. He might choose to not testify or might testify knowing what's going to happen. The last thing you have to know is that under CPL, under Criminal Procedure Law 260.20, a defendant must be personally present during the trial of an indictment. And that has been interpreted to mean the defendant has a right to be present during any material part of the proceeding where his presence would be helpful or necessary. Okay, so what are the facts in this case? The facts are the defendant was charged with possessing a defaced firearm and possessing a loaded firearm outside of a home or place of business. Before trial, the prosecution, pursuant to the rules, presented a Sandoval application, filed an application saying, I'm going to ask the defendant about this and this and this and this and this and this if he testifies. Those things included 7 prior convictions, 1 pending case, and criminal conduct underlying all those offenses. Before the case was heard on the record with the defendant being present, the judge had the attorneys come in the back, the prosecutor and the criminal defense attorney. So the defendant's attorney was in the back in chambers. And the judge said, let's go through this and have a conversation before we go out in the record. And they had an in-chambers, off-the-record conversation in chambers without the defendant being present about all these different parts of the Sandoval application. They had some kind of discussion that was not memorialized. Then they come out and do the actual Sandoval hearing. On the Sandoval hearing where the defendant is present, the judge says it's going to make a ruling on Molyneux and Sandoval and asked if the defense counsel wanted to be heard first. The defense counsel said it would rely upon what was said in chambers. The court then made a ruling, granted some Sandoval relief, denied others, allowed, the prosecutor to mention a felony conviction, a misdemeanor conviction, but not underlying facts, did not allow violations to come in, did not allow the pending case to come in. Then the court conducted a bench trial where there's no jury. The judge conducted the trial, found the defendant guilty, and sentenced the defendant to jail and post-release supervision. The defendant then appealed. And the basis of the appeal is, I was deprived of my right to be present during the Sandoval hearing, during every material stage of the proceeding. It goes to the appellate division, and the appellate division affirms the conviction, says the defendant was not denied the right to be present because on the record, the judge said, do you have anything you want to say? And the defendant was there. It goes to the Court of Appeals, and here they reverse. They reverse the conviction. They say 260.20, which is that statute that says the defendant has a right to be present during every part of the trial, material stage of the proceeding, means that whenever the defendant has something valuable to contribute, can meaningfully participate, that's when the defendant has a right to be present. So here, the conversation about the Sandoval application took place in chambers. That was where the defendant had a right to be present. It doesn't matter that he was present in the courtroom when it was sort of a perfunctory, does anyone have anything they want to add? They say the actual hearing, the actual application arguments took place in chambers, and that means the defendant had a right to be present. And why? They say because the defendant could rebut or contradict the prosecutor's assertions. If he's not present, he can't rebut or contradict them. The defense counsel's not the one that has the right to be present. It's the defendant who has the right to be present for those conversations. So it's a violation of the defendant's rights, conviction reversed. And that's the case of People versus Sharp. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.